supply chain, from trading and trade finance arrangements to international recoveries and arbitration. He's a leading name in trade fraud cases and regularly assists clients with investigations, security enforcement, and trade finance structuring. So today, Baldev is going to talk to us about the key lessons in trading and trade fraud. The past 2 years in trade have provided valuable lessons for those in trade finance and the risk assessment that should be taken in assessing a borrower or credit risk for both traders and lenders alike. And we will tap in our extensive experience and recent Singapore case law to deliver into key practical issues of double financing, security enforcement, circular sleeve trades, and restructuring or insolvency. So I'm just going to ask everybody 2 things. The first one is to please put your microphone on mute, because sometimes there is some back noises that can be disturbing. And the second one is that Baldev will be answering all your questions at the end of the sessions. So the floor is yours, and thanks again for being here with us today.
Thank you, Yasmina, and thank you to the Zug Association, Zug Commodities Association. Hi, everyone. It is a small group, so I will try to answer your questions. I hope it's not all your questions, but I will try to answer your questions towards the end. Thanks for joining me. I think for the next 45 minutes, I'll talk about some of the lessons we've seen in trade and trade fraud. And naturally, a lot of it gravitates around Singapore. That's largely to do with the 2020 trade fraud cases that we had and the effects of it going into court litigation in 2021 and then in 2022. Just as a footnote, when you hear the concept of Singapore law, it is for most part, when it comes to international trade, for most part, it is almost identical to English law. The concepts are the same, the case law is the same as well. So whatever that we see over here would apply, I think, quite persuasively under English law as well. So let me get started. And I think I'm often asked what are the lessons to be learned from all the different trade cases that we've been doing. And I think in particular, trade fraud in particular was exposed in 2020 because you've got shocks to the system. And what has come about is that we have found a problem in trying to connect trades to invoices. So the business of international trade and commodities financing, it's one that's very heavily focused on liquidity, on being able to have liquidity and financing. Once there is a micro event in the company or a macro event affecting the world, then the whole pyramid starts to get tilted. And what we will see is that you'll see all sorts of defaults that come around from it. Some of the defaults are legitimate. They are simply because the company is going through a bad time. But other times when there's defaults, we tend to see that it's been fabricated around a circular trade or a structured trade, or even a fictitious trade. And these trades are highly leveraged to get better credit and financing positions. And that leads to the whole capitulation. And sometimes the capitulation tends to be quite spectacular. So what have we seen? We've seen one way of raising money is actually to do invoice financing. You issue your invoice, you then send it off to a financer, and then that person pays your invoice at a discount. The problem with invoice financing is that naturally it is quite hard to attach the invoice to the trade. Because the invoice is on a piece of paper and the BLs are on a separate piece of paper, then to identify your particular trade to a specific BL becomes a bit difficult. The business of invoice financing is one that's done on a volume basis. They are looking at the surface of the documents and less so on investigating the trades itself. So we've noticed some trends, one being that a BL can be, financed multiple times. And so invoices can be raised multiple times over the same trade. Otherwise, you've also got many different segmented parts of the trade, many different links being created to give the impression of of liquidity within the chain, when actually that it might actually just be a circular trade, starting and ending with the same person. And we've also seen a trend of using insurance, credit insurance, as a means to an end, a means of getting more liquidity into the chain. I'm going to briefly talk about three things in today's webinar. One is about double financing and some of the red flags we see in double financing. This is particular to commodities trading. The second part is to do with letters of credit and how they apply when dealing with circular trades or when dealing with financing trades. And the third part I'll talk about would be misdelivery claims. And misdelivery claims apply specifically mostly to banks, when banks are pursuing ship owners for misdelivering cargo. So three parts of it. I'll take about 10 minutes in each part. And so we'll start with double financing to start with. Double financing I want you to focus on the left side of the screen. Double financing, a trade can start from A and then it goes on to B, C, D, and back to A again. That's a circular trade. A trade originated from A that goes to B and then to C and D and back to A again. There's nothing, horribly objectionable about a circular trade. There's a reason for it. People do circular trades to arbitrage positions, to tap on their credit lines, and so on. The problem with circular trades, though, is that it's not always disclosed to every party involved. So you might have party C that's inserted into the trade who does not know about party A. It doesn't know that it's being asked to do a trade on which it receives papers and it sends it back to party D, and then it goes up to party A. Why is this important? It might not be so important for party C itself. It's just earning a margin for sending the documents through. But it would be more important for party C's lenders, who would need to want to see the full chain, because ultimately, if you are lending to party C to pay party B, then if it's a purely financing trade, that changes the risk metric somewhat. And likewise, if you're going to credit insure this trade, then the insurers would want to know this as well. There are some telltale signs. I mean, the nature of trade fraud keeps evolving many different times. You have different modus operandi. But there's some telltale signs in the documents itself, because when a trade is being created as a pass-through, I think sometimes you see the party B might be listed as the exporter, when actually it is not the exporter. It cannot be the exporter, because to be an exporter, you need to be a local company in that country. Other times we've seen that by the time a certain party claims to be part of the trade or claims to have received the BLs, the goods have actually been discharged. So when we go and uncover and discover trade fraud, what we see is not just the left side of the screen. We then see the right side of the screen. And then we see that the entire trade has been mirrored by inserting a whole new set of parties, E, F, G, and H. And by creating this, same number of parties, same movement of goods from country A to country B, involving multiple lines of financing. You can just count the number of parties now that are able to get financing for what is effectively the same set of goods. Another way of showing this diagram, and something we see very much more recently, is this creation of a fictitious trade that is not connected to the actual real trade itself. So on the top side of the screen, we have a shipper who then sells goods to a buyer onto a receiver. That's the legitimate chain that's going about. The parties are using actual bills of lading, BLs, to buy and sell the goods. And then to raise financing, the bottom half of the screen is created using a photocopy, for example. So party A, B, and C put together a trade chain. And if you are a bank, being introduced to this transaction, all you see and all you ask for is party A, B, and C, and you think, okay, looks all right, and you're willing to lend money onto this transaction. The difficulty here is that no one knows where the connection is between party A and party C to the actual trade. So this is, there's no other better way of describing it. It's fictitious. It's a figment of imagination being put forward. And the reason why this is being put forward is to get access to more financing. So the A, B, and C, it's just kept in suspension. It's just hanging there. The documents never move further from party C. It never goes back into the real chain. It is just a snapshot of a fictitious chain being created and left there hanging. I want to now touch on a more complicated area, which is letter of credit and how the claims arise in letter of credit. So remember what I spoke about with double financing, with circular trades. Now, how does that apply in the context of LC claims? And LC claims in particular, in Singapore, we had two claims whereby the bank had to pay or could not claim back after having paid on its LC. The LC was held to be enforceable and payable. Naturally, if you're not familiar, LC claims under English law, as it is under Singapore law, it is very hard to renege on the promise of paying under an LC. If a bank issues an LC, the only reason it cannot pay, apart from non-compliant documents, the only reason it is entitled not to pay would be when the beneficiary is guilty of fraud. And that's a high bar, because in the diagram I just showed you before, many parties are inserted into the chain. Each one might not know what is going on. They are just a useful conduit to the situation. So let's start with the first LC claim. This is a case of Credit Agricole versus a company called PPT. And it looks complicated, but let me try to explain the genesis of it. In this trade, we had a real actual trade being put together and being financed. And that trade is in green. Total was selling on to Soka. Soka was selling on to a company called Zenrock in blue, and Zenrock onto Total. So if you follow that green line with ING at the top, ING was the bank financing this transaction. Now, if you look at I've put the pricing into it as well, because this happened at the time of the oil crash in March 2020. So the pricing is actually negative at that time. And so Total sells to Soka, Soka onto Zenrock, Zenrock onto Total. Zenrock gets its bank, ING, to issue an LC in favor of Soka. All of that is fine. But then subsequently, what Zenrock decided to do is create a whole new fictitious chain in blue. And they decided to mirror the trade by using the same start point, which is Total, and the same end point, Total again. But in between, they started to create a circular trade of its own. And in that circular trade, Zenrock then applied to another bank, CA, Credit Agricole, at the bottom, to then issue an LC in favor of a company called PPT. If I put it bluntly, PPT in this situation was what I call a useful idiot. It was asked to enter into this transaction first it was asked to enter into this transaction first as a seller, then later as a buyer, at whatever Zenrock's bequest or behest was. And Zenrock told PPT what to do, what margin was set for it, when to receive the documents, and who to pass it from. PPT did nothing but just took the documents, sold it on to, passed it on to Zenrock, and then sought to claim on the LC. At the time that PPT sought to claim on the LC from Credit Agricole, Credit Agricole came to learn that something was wrong. There was rumors in the market that Total was being asked to assign the same contract twice over. So Total's at the end, and that's where it started to get uncovered, because ING started to find out that the blue transaction was actually getting in play. And then Crédit Agricole suspected that, wait a minute, this contracts in blue might not seem legitimate. So Crédit Agricole did not pay on its LC. And then as it turned out, this transaction was actually a fabricated transaction, in the sense that Zenrock created a fabricated contract with Total at the end of the screen for Platts plus $3.60. So it's not, when you look at all these crazy schemes, people think of it as sophisticated fraud and high level thinking that went into it. Not quite. I think ultimately Zenrock just took what was the price, which was Platts minus, and just put a plus sign on it and said Platts plus, and then created a fabricated contract around it. The key point about this whole transaction was that PPT knew it was a circular trade. It knew that the goods or the parent trade was originating from Zenrock and going back to Zenrock again. It knew it was circular. It knew that it was being asked to, at one time to be a buyer, at the other time to be a seller during the negotiations. It knew that the pricing that it was asked to put into the contracts was wildly off. And that was the reason why Crédit Agricole then said, wait a minute, we're not going to pay because PPT is fraudulent in its presentation under the LC. And what did the court say? I mean, the court said that, no, they weren't fraudulent. I mean, PPT knew there was round tripping, but the important point is that they did not know the prices were inflated. This, my own personal view of the case on this, is that it sounds quite unbelievable for an oil trader to not know in March 2020 that prices had gone completely through the floor and had been in a negative market. And when it sees a contract that talks about a positive pricing, that sounds to me quite unbelievable. So that's where I think the court, based on the evidence put before it, said no, PPT had no knowledge of the inflated prices. I wasn't in the case, or I wasn't involved in, I wasn't the trader, so I can't really say, but it seems a bit far-fetched from my view of it. But the most important finding out of this is that while PPT might have been, while PPT was not dishonest in the sense that it didn't know of the fabricated Total contract, it didn't know about that tail end, it didn't know Zenrock's full plan of creating a fake contract, it was still reckless. PPT didn't really verify whether it had title to the goods. It didn't really verify why it was being inserted into the chain. It didn't do any of that. It just, as I mentioned at the start of this, they were what I call the useful idiot. They just presented the documents as told. And as a result, the bank didn't want to pay. Ultimately, the court said that the bank had to pay because even though PPT might be said to be reckless, that is not enough for the bank not to pay. This decision, this basic finding that you can be reckless but not fraudulent, is something that I personally don't agree with. I think if you are reckless in the sense that you are indifferent whether something is true or untrue, that to me is the definition of fraudulent behavior as well. The court in this case didn't agree. I mean, they took a very narrow view that fraud means dishonesty and dishonesty alone. And so that's why I think there's a bit of criticism that has come out from this case. And that criticism may well be well placed or not well placed, we don't know. What I can tell you is that this decision, this is a first instance decision in the courts in Singapore. It's then gone on now to the Court of Appeal, which is our final court of appeal in Singapore. And it's pending its decision there as to whether the decision gets overturned, i.e. whether Crédit Agricole needs to pay, or whether it cannot, or whether it's a judge to not being liable to pay because the underlying contract was circular or was fictitious. I've got some language over here about from the judgment itself that talks about dishonesty, and in particular that a reckless failure to ascertain the representations made in the documents. Because if you are PPT and you're putting forward these documents, you are saying to the bank, yes, I am or I was owner of these goods. Yes, I entered into a contract for these goods, and yes, these goods are, legitimate. The contract is legitimate, and that I find it still. If you're reckless about it, then perhaps there's a question mark as to whether that presentation is said to be a bona fide, honest presentation. The court disagreed, obviously, but we'll have to see what the final decision is, which I expect to come out in the next few, quite shortly, I would say, in the next month or two, I would think. These are the examples of what we thought was PPT's reckless behavior. I'll just leave it in the slides over here because I don't want to go into too much detail. But let me move on to another case, which is also dealing with the 2020 collapses of some of the oil traders in Singapore. And this is a case involving UniCredit and Glencore. Now, in this case, I'm going to explain the diagram in front of you. You have Glencore UK selling oil to Glencore in Singapore, I believe. And then Glencore Singapore onto Hin Leong. And then Hin Leong sold it back. That's why there's a buyback contract. Hin Leong sold it back to Glencore. And that's the transaction that was put in place. Now, Hin Leong had an LC open, and Glencore presented the documents under the LC. UniCredit, being the bank that opened the LC, paid out on it, and then subsequently learned that actually Hin Leong has gone into insolvency, and it did not want to, and Hin Leong was accused of fictitious trades. This wasn't a fictitious trade per se, but the point of the matter was that UniCredit said, wait a minute, I should get my money back for this letter of credit because of the buyback contract. Because the buyback contract was actually a buyback contract, in a lay person's way of thinking about it, a repo contract, is effectively a circular contract. You're selling and then you're buying it back again. And that is a purely financing arrangement. And UniCredit was arguing, saying they were never told it was a financing arrangement. It made all sorts of, UniCredit made all sorts of, or had all sorts of grievance because it felt this trade was not a legitimate trade. It said it was not a legitimate trade because there was that buyback element, number one. It said it was not legitimate because the BLs never moved from Glencore to Hin Leong. Instead of the BLs, there was this mechanism of a letter of indemnity that promises to give the BLs if needed. So the main objections that UniCredit had in this case was that this whole transaction was circular. No one told them. This whole transaction was a financing deal. No one told them. This whole transaction did not involve delivery of actual goods or delivery of BLs, and no one told them about that. So this transaction, they allege, was a sham transaction, a transaction that did not represent what it was meant to do, which is a sale of goods. The court disagreed, and I think this case, unlike the Credit Agricole case, this case I think is spot on, and I agree with what the court had to say about this. So the court said, ultimately, the motive for the transaction is irrelevant. If it was done purely just for financing purposes, that is irrelevant. The bank, UniCredit, cannot complain to the beneficiary because the beneficiary owes no duty to the bank to say that it will give disclosure of what the true trade was. All of these complaints the bank had, UniCredit had, should have been directed to its applicant. Its applicant was Hin Leong. And if Hin Leong didn't tell them what it had to tell them, that was the risk that the bank took on its applicant, and that the recourse should have been on Hin Leong and not on Glencore instead. naturally, because Hin Leong went bust, so they tried to claw the money back from Glencore. So the transaction motive is irrelevant, but also more importantly, the title, transfers of title. The transaction cannot be a sham because there was quite an accurate importance and stress placed by the parties in the transaction on when title passes. They passed the title on a minute difference between one and the other. So parties sat down and said, okay, we'll pass title on 2359 on day number 1. The other party will get it at midnight, and then they'll pass it over at 12:01, for example. Parties were applying their mind to the passing of title. The fact that Hin Leong itself never took the goods or never took the BLs, I think were irrelevant, because this wasn't a case where because Hin Leong could have sold the goods to somebody else as well. So it wasn't the case that Hin Leong was promising to be the end receiver of the goods or the consumer of the goods. It could have always been on sold to somebody else. And so the bank can't really have an objection about that. And most importantly, I think this big question mark as to, where are the BLs in this transaction was actually also neither here nor there. It's irrelevant because the parties already contemplated not having the BLs. That's why they had the letter of indemnity mechanism. They said that they're not going to use BLs. And ultimately, because Hin Leong was selling back to Glencore didn't really, that's a good reason why Glencore didn't have to give it the BL. It's only 1 minute and still holding on to its BL. The key point on the BL evidence was that Glencore's evidence was that it wasn't the case that there was no BL and they could never find the BL. Glencore said that if it was required, it would always go back to its sister company, Glencore UK, and get the BL. And I think that was particularly convincing for the court. These are some of the arguments that have been put forward in the case. I'll leave that on the slides, but it's more legal arguments that I think it's been covered in the slide before in any case. Let's move on in the next 10 minutes or so to the last section of the talk, and that will be on misdelivery claims. And before we start, let me give you a bit of background as to how misdelivery happens. A bank looks to BLs as its security typically, and so it will ask for BLs, or if not, there is an LOI, as we mentioned before. An LOI means that at some point someone will deliver the BLs to one of the counterparts, or ultimately the BLs will end up back at the bank. And a bank holds on to BLs because it gives them very good security in being able to go after a ship owner if the goods already had been discharged, and saying to the ship owner, listen, I am the lawful holder of this BL, so you must give me the goods. And if you don't give me the goods, then you are then liable to me for misdelivery. A misdelivery claim in law, it's notoriously difficult to defend against. If there's a misdelivery claim, owners tend to capitulate quite quickly. And if they fight it out, it doesn't even go to trial. It goes into what we call a summary judgment, meaning that the process doesn't need to, you don't need to interview witnesses, you don't need to go through the full hog of trial. The case can be decided quite quickly and quite on its surface that that the ship owner has been guilty of misdelivery. So most ship owners are terrified of misdelivery claims. Most banks are keen on holding on to BLs for that very purpose. It gives them a second bite at the cherry, so to speak, because if the bank's borrowers default, they still can go after the ship owner. It is another way of getting what is effectively sometimes tens of millions of dollars. So misdelivery claims and how the last year has created a new complexion to how misdelivery claims are done. In this case, once again involving Hin Leong, what we had a company, Winston, selling onto Hin Leong, then Hin Leong onto Hin Leong's buyers. OCBC was the bank that were taking the BLs from Hin Leong, and they had a, naturally a facility with Hin Leong, and in return there was a trust receipt given towards OCBC. Ultimately, the BLs at the time, the BLs were not in play because people were using payment LOIs and letters of indemnity instead. But what happened is that Hin Leong in the middle, what it was doing was that it was taking a certain cargo, blending that cargo, and then selling it to its buyers. And this is the key point over here. So the bank, eventually the bank got the BLs, and the banks were holding to the BLs like its life depended on it. But the BLs referred to cargo A. Cargo A was what Winston Oil was selling. Winston sold it to Hin Leong. Hin Leong then blended it into cargo B and then sold it on to its buyer. So when OCBC finally got its hands on the BLs, it went to the ship owner and said, pay me for misdelivery. And one of the defenses by the ship owner was that, wait a minute, you weren't really holding on to the BLs in good faith. You weren't really holding on to the BLs as security because you knew, OCBC, the bank, you knew that the cargo was blended. So that BLs can't be worth what it's meant to be worth. This case, the STI Orchard, the important part about STI Orchard is that it is, remember I spoke to you about summary judgment, that on misdelivery claims, it goes into summary judgment because it's a sure win for the bank. In this case, the bank did try for summary judgment and they did not win, meaning that this case now is going on to trial. So it's not final and conclusive just yet, but I think it's quite important because it highlights a very key point. And the key point is this, that at the time the bank was taking the security of the BLs, it already had noticed that Hin Leong was going to blend the cargo. So new BLs would have been issued. And if new BLs will be issued, the banks then can't really rely on their old BLs as security. A similar case then happened a year later involving Standard Chartered and Maersk Tankers. Similar, not too dissimilar fact pattern. You also had Winston Oil, you had Hin Leong again, this time different bank, SCB, Standard Chartered. And so the case went for summary judgment again, and once again, it didn't get past the summary judgment level. So it has to go to trial because the court thinks, wait a minute, there is an arguable defense over here worth pursuing, that the owners can pursue. And the crux of the matter over here is that at the time the LC was issued by Standard Chartered, it already knew that the cargo was discharged, that Hin Leong had discharged the cargo. So Hin Leong applied for the LC on 3rd March, and that's after delivery to its buyer. So even the LC application form, it puts the latest date as 29th February 2020. So the bank would have known that this cargo had already been discharged at the time it was issuing its LC. So the fundamental question once again is, Mr. Bank, how can you be relying on this document as a security if you knew that the cargo already had been discharged? And that had been couched in the form of causation. That is not really, it's not really the misdelivery that caused SCB's loss. SCB's loss was simply because its borrower didn't pay. So it had nothing to do with the security because this wasn't really a security. This argument found favor with the court, once again on a summary judgment level, but not at its finality. So this is still going through the courts. It's still going through the courts to be decided. But I think it changes the notion of what is typically seen as a gold standard claim when a bank has a BL. I think, let me see. There's more reasons for it on the slide over here, but that is me in a nutshell then. I think we've got some time. I think that's it for my talk over here. So if you guys, I'm very happy to take any questions that you have. Since it's a small group, please let's have it as interactive as possible. Any questions, or have I put everyone to sleep?
Thanks a lot, Baldev. And I don't know, I think that someone unmuted. Anyone has any question? It was quite a vast topic, lots of many information. So
yes, it's quite technical in nature. That's why I didn't want to go into too much legal jargon as well, because it's quite technical. But I think if I could summarize the points again, the three main parts of the talk. One being is that the cases have shown a trend of double financing, and that's largely because double financing is so easy to do. The reward of getting double financing outweighs the risk of getting caught. And I think that's what's been demonstrated in the past few years. On letter of credit, I think the notion of how banks have to pay on a letter of credit does not always sit very comfortably with how trades are structured, and circular trades and financing trades are created. And ultimately, the bank cannot really look at the beneficiary and say, you did not tell me A, B, and C. It is the bank's applicant that it has its own, that it takes a risk on, and ultimately that's where the risk stays. The third point on misdelivery claims is that if a bank wants to hold on to a BL and say that this is their security, then they need to do it with their eyes open. They can't hold on to that piece of paper, tick a checklist, and then ultimately they know that the cargo is gone, or they know the cargo has been blended, and still subsequently claim that they are holding on to the BL, and so they won the goods. So these are the three learning points that we can put together.
great, thanks. I think that Katie, you had opened your mic before. Did you have a question?
I think, thank you very much for the presentation. I think you covered very well, and I think answer all the questions is very transparent. The only thing which builds or created a curiosity in me is the fact that if you put in a position to be a funds of to finance a transaction, how do you protect yourself?
You're talking about as a trader or as a bank?
Yeah, so like a trader. So how do you protect yourself?
Ooh, I can give you an answer, but I don't think it'll be a realistic answer. How do you protect yourself from what might turn out to be a fictitious trade? Is that the question?
Correct.
Yeah. Okay, my answer in short, I think, is that each person within the chain needs to be able to justify commercially why it's in the chain. The moment someone puts up their hand and say, I'm just a pass-through, that to me is a big question mark. Why is that person in this? If we go back to all these weird and wonderful drawings, why is party B or C or D in this chain? That needs to be justified by each party. So insofar as you've been asked to, a trader has been asked to pass documents through it to another party, I think that's where the danger lies. There's this notion of a pre-structured deal where margins are fixed, the buyer is fixed, the seller is fixed. All you have to do as a trader is keep quiet, send the documents across. And I think that, to me, I say it's an unrealistic answer because I would say that you have to put your hand up and say, why exactly am I sending the docs through my company? Naturally, if you are a smaller trader, you always want to have a big trader in between, because that gives the trade a sense of legitimacy. You want to have one of the big names up there as well, because then no one's going to ask any questions. But in this trade, it's all about deflection and trying to create a sense of a legitimate trade happening. And ultimately, the questions that people have to ask is how did each party get involved, and what is its role in it? Because in the cases that we see, some small traders explain that they are the ones providing financing, and we think, no, it can't be. You can't be providing financing to one of the largest traders in the world. It just cannot. It doesn't make any sense. So that's my unrealistic answer, because I just know that in this business, people want to earn a margin, and so the less they ask, the easier it is to make top line.
Thank you. I think that's kind of feed my curiosity at that stage. That will be all from our side.
Okay. Well, I'm happy to share the materials across to the association as well. And
Yeah, I think that there is one more question, Peter.
Oh yeah, thank you so much. Thank you, Balde, for the nice presentation. Allow me to just go off the tangent and ask something related to structured LCs. I don't know whether it will fall under this. I'm from Kenya, and I've seen of late there's a lot of solutions that have been provided to banks in African countries who are struggling to get USD and foreign currency liquidity. So what they do is now go and approach some of the traders. Mostly I've seen a lot of this coming from the Middle East. So basically the local banks, the African banks issue an LC, and there's this structured trade that is created so that the LC is issued. I don't know whether you come across these structures. So basically what happens is there's a confirming bank for the offshore trader, who then gives money to this bank in Africa, and by that the African bank gets liquidity, basically in the form of foreign currency. But basically, if you look at it, there's no trade that's going on in some of these instances. There's sometimes exchange of photocopies of bills of lading and some other documents. I don't know that you've come across this, and it's really been difficult for us African lawyers looking at this, because it's a new structure and you're not sure that whatever is happening there is correct. I don't know if you have a comment for that.
I have come across it, and I think I'm a bit hesitant as well, because I've never truly understood. I think the world of structured trade, and in particular structured LCs as well, it's got very little to do with the trade per se, I think. And that, as you mentioned, there is no trade in large part as well. They're taking a position between each bank, largely for foreign currency movement. And so my only observation there is that when you do structured LCs, all of these cases wouldn't really apply, because the bank can't turn around and say, oh, I didn't know there was no trade at all. I think the risk that it's willing to take in a structured LC is quite different. And I think it'll be hard pressed for anyone in that transaction to lift his hand up and say, oh, I really expected there to be a trade, physical movement of goods from A to B, because that's not the nature of a structured LC. It's a different risk being undertaken, but I suppose it seems to stay in a very small group of banks that do this between themselves. So that's why it doesn't come out into full-blown litigation, I suspect.
Okay, thank you so much. That's helpful.
Well, Dave, hi, Deval here.
Hey,
Thank
Deval,
you for
how's
the
it
lovely
going?
presentation. How good.
My pleasure.
Lovely. A couple of questions on my side. At the end of the day, it's structured trade is a structured trade, right? That's what the name it is. People do these transactions for various reasons. To structure it basically, and the main purpose is to basically raise financing, either for the smaller buyer or the big buyer or the big counterpart that's involved there, to earn margins. Everybody has their own purpose in it. But ultimately, with all the frauds that we've seen in the past few years, right from the Qingdao and the last couple of years frauds, it's the banks who've lost the money, right? Yep. Ultimately, they are losing the money. At the end of the day, none of the big trading houses, because it's structured in such a way that it's hard to pinpoint any. You can bring out any issues, but at the end of the day, then in the legal battle, it's the banks who lose the money all the time rather than the big trading houses. Is that correct?
That's quite astute. That's correct. That's if you just look at UniCredit and the Credit Agricole case that I highlighted on the screen as well, both of which the bank couldn't get its money back. It had to pay on the LC, and it's simply because that's the risk the bank took on.
Mhm, mhm. Okay, and what has happened in terms of all these frauds that have taken place? What's happened to the guidance or management, the owners and stuff? Because you don't hear a lot about that after the fraud has happened. It never really
What's happening?
comes
What,
out.
sorry?
I'm saying you don't really hear about the management, the owners, in terms of what's really happening to them. Because that's also critical, right? I mean, they were the main culprits who basically had the idea of creating this whole fraud. Companies are companies, they are sufferers, banks are sufferers, but ultimately, do you think, are we getting into a chain where, you know, the policies can be set up in such a way that can basically help, you know, people even trying to avoid such frauds by the local governments and most of the trading communities like, you know, Singapore, Dubai, Switzerland, Hong Kong? Are they working out something behind this? I don't know. It's a very broad question in general, but we don't really see much action being taken behind the people who are running these shows. I mean, you know, and it's a repetitive
I
game.
agree. I mean, ultimately, what's being done is that they're trying to create trade finance registries, electronic BLs, all these different systems to mitigate or minimize the risk of one BL being issued, let's say, being used more than once or twice. But to your point as to what the repercussions are for the people that have orchestrated it, and I say this from years and years of doing it, that it is, you know, 2020 wasn't the first time scandal of this nature had come out. It has happened all over the world. And I from what I've observed, not very much, unfortunately. Not many individuals have been, you know, taken to task or thrown into jail. In Singapore, people are still pursuing the owners, but I don't believe it's ended in any final conclusions yet.
Okay. No, perfect. I guess the topics were quite interesting. Always good to hear from you. Thank you.
Thank you. Pleasure.
One more question? Okay, so thanks a lot. So you are going to share with us and all the participants your presentation, or yes?
Yeah,
Okay.
no problem.
And on top, we have also recorded this session, so we are going to let you know when it's up on our YouTube channel, so everybody can watch it again if there is, or if they want
Sure.
to promote it to some other people. So thank you so much. We really appreciated your time and coming and sharing with us this very interesting and quite important topic. Yes, Andrea? Or Katarina? I don't know who raised the hand. No? Okay. So anyway, thanks a lot to everyone, and yeah, see you soon for our next event. Thank you.
Sure. Pleasure. Thank you, everyone. Goodbye.
Bye.
Thank you, everyone.